In this lecture, we're looking at another term. This is very interesting. We've looked at several terms, students, and all of them are tied to the Constitution and very important in legal cases. And we have to understand those terms because as you move into your various academic areas, and some of you going to law school, it's very important to understand these terms, the fundamental meanings of these terms, and how they impact cases across the spectrum. So today we are looking at prima facie evidence. And if we translate this in English, we begin to get a sense of what it means and how it impacts cases across, again, the spectrum. And so let's take a look at this very closely. Prima facie is a Latin term meaning at first sight. All right, so let's pause here. At first sight. What does that mean, students? At first sight. If you see something for the first time, what impression do you get? What reaction do you get usually at first sight? And some of you have fallen in love with your girlfriends or your boyfriends at first sight. Is it not? I know nobody will admit here, but I am sure for some of you that is the case. At first sight, you fell in love, and now whether it worked out or not, that's a different case. We're not going to get into that. But at first sight, right, or on his face. Now we can also add value on its face value. Right? You take something at face value. What does that mean? It means the way you say it, that's the way you take it. With very little analysis, with very little evaluation and measurement and assessment, right? You take it at face value, all right? So at first sight, on his face, referring to evidence that is sufficient to establish a fact or raise presumption unless disproved or rebutted, right? Again, take a look at this closely, students. When you look at this, you look at something on face value, and sometimes it's sufficient to prove or disprove a case. Let's look at it one more time, referring to evidence that is sufficient to establish a fact, right? A fact, or raise a presumption unless disproved or rebutted, right? So sometimes the face value at first sight, you can make a conclusion and say, well, this is guilty or this is suspicious, right? And based on that, you can take further action. For example, if a motorist is driving down the road and is going from side to side, uncoordinated, and going at high speed, what do you think usually is happening there? It's either drunk, it's either a very immature driver, someone who doesn't care about road safety and doesn't care about his life. So at face value, you conclude just by seeing that person that they are breaking the law. Now, that person could have a medical situation. You don't know that. That is not the conclusion. That is not the initial conclusion. The initial conclusion, students, is that this person is breaking the law and this person is reckless deliberately and this person must be stopped. At face value, you make that conclusion without any assessment, without any evaluation, right? And if you evaluate what is going on, you may find out that there's a medical situation happening. For example, and the person is unconscious and the car is just swerving from one lane to the other until it crashes somewhere, into a tree or into a concrete or something along those lines, right? So at face value, you make that conclusion. And it says here, referring to evidence that is sufficient to establish a fact, right? And the fact in this example is reckless driving, is disregard for life, right? In this case, or raise presumption unless disproved or rebutted, right? So to disprove it, this was actually caused by a medical situation. And there is no reckless driving here, right? You disprove that. But that's upon further investigation. So prima facie is a very important concept. It represents the minimum amount of evidence required to support a claim or defense before a trial, allowing the case to proceed. Now, let's take a look at the example we gave. So then, based on what you see as a police officer, you can begin to chase the driver, right? You can begin to pursue that driver to see what's going on, because what you have seen is a driver going from lane to lane in an uncoordinated fashion. It represents the minimum amount of evidence required to support a claim. Minimum, right? And this is a key word here. Minimum amount of evidence. No research, no evaluation, no assessment, no critical thinking, right? Just minimum to give you a suspicion. Another example would be somebody walking into a store and approaching the counter and suggesting that they have a gun, suggesting that something is taken out that looks like a gun. It may just be something that is a toy. It may be just a toy. It may be wood or an object that's not even a gun, right? But it looks like a gun. And they are approaching the counter and the cashier, right? Your conclusion is they are coming to rob. Face value, that is your conclusion. Face value, without talking to the person, without waiting to see what the person will do. You make that conclusion and you draw your weapon to take action. That is the minimum amount of evidence you need. Whatever is taken out and the way the person is walking to the cash register will suggest to you that they are coming to rob the store and you take action. That is the minimum evidence you need. And the evidence is the menu, in this case, right? The evidence is the behavior of the person, right? Behavior of the person. The evidence is whatever is taken out, right? Taken out from the waist, right? And the person is holding that thing, whatever it is, and walking furiously to the counter. Minimum evidence. Maybe the person is coming to report something you may not know. Maybe the person is very hungry and they don't care about their behavior. They don't care about how they're walking. They're not even aware that something is taken out. It could be a can of Coke. They're not even aware, right? And you conclude that they're coming to rob the store, right? Minimum evidence. So it's important for us to have this context, to understand what this concept means. The prima facie, what it means, how it's used. And sometimes the courts have allowed this type of evidence to come, and they wait for further proof. And sometimes they dismiss it because there's nothing there, there's nothing to see. And sometimes they pursue it further because there is something to see. Let's take a closer look at this. All right, so what are the key aspects of this concept? The definition and function signifies that at first glance, the evidence is enough to prove a case. If the opposing party fails to produce contrary evidence, well, guess what? The prima facie evidence may be sufficient to win the case. If it's not disproved, it may be sufficient to win the case. Let's get back to the road example. If you go as a police officer to the driver, you finally catch up with the driver, who take a look, and there's no medical emergency, well, then there's nothing to disprove. There is no excuse for the reckless driving, and you make a conclusion that this person has broken the law, and has broken the law deliberately, intentionally. So it says here, at first glance, the evidence is enough to prove a case. If opposing parties fail to produce contrary evidence, nothing to say that, this is not the case, to disprove, well, then prima facie will prevail. It will prevail. It's sufficient to win the case. The party with the burden of proof must present prima facie evidence to avoid dismissal and to shift the blame to the other side to provide rebuttal. Again, we'll come back to the car situation. So this is the car. Let's draw a car here. This is the car, and the driver is speeding, and the driver is swerving, is going from lane to lane because of medical condition, right? This is medical condition. And you suspect that is reckless driving, right? As a result of drinking. The driver is drunk. That's what you suspect. So you go to the driver and say, you are drunk, and I am taking you in. And the person says, no, I'm not drunk. I took a medication that has gotten the best of me. Or I just fainted while I was driving. This evidence is sufficient to dismiss this. Sufficient to dismiss this. Where there is no evidence, this evidence stays. You understand the point? This evidence carries. If there is no medical condition, no mitigating evidence, no mitigating circumstances or circumstance, this carries, and you can win the case based on this. Once again, the party with the burden of proof must present prima facie evidence to avoid dismissal and to shift the burden to the other side to provide a rebuttal. In terms of application, it is used in both criminal and civil law. In both criminal cases and civil cases, it is used to determine if there's enough evidence to justify a trial. Can we move forward based on what we have? Do we have enough to sustain a trial, or are we wasting our time? And based on that determination, they move forward or they do not move forward in both criminal and civil cases to determine if there is enough evidence to justify a trial. At face value, we have enough evidence. We have enough evidence. Let me give you another example. You go into a room, you hear people screaming, and somebody runs out of the room with blood on their shirt. And they're running out and escaping, and you conclude that they must have committed a crime. And you go into the room and you see somebody else lying on the floor in a pool of blood. And you conclude that this person was responsible for that situation. And you charge this person to court. What is your evidence? You did not see the act. What you saw was somebody running away with blood on their shirt. And you conclude that they must have committed a crime. And based on that, you pursue the case. And that is at face value. At face value, at first sight, you conclude that a crime has been committed. Now, there could be somebody else who has committed the crime, and this person running away is also a victim and is running away to call for help. It could be that. But at first sight, that's not what you think. That's not what you see. That is not what you see. At face value, what you see and what you conclude is somebody running away from the scene of a crime, and that person must be responsible. In criminal law, evidence sufficient to convict if the prosecution's case is believed. Sufficient to convict, right? If it is believed. If there's no rebuttal, please take note, students. If there is no rebuttal, it is sufficient for conviction. If you have a rebuttal, well, then there's trouble. And you have to take a look at this closely to see what is believable, whether the prima facie evidence is believable. In a criminal case, evidence is sufficient to convict if the prosecution's case is believed. In a civil case, in a discrimination case, for example, a plaintiff must establish a prima facie case to demonstrate that if believed, the claim is sufficient to justify a verdict. In a civil case, the plaintiff must establish a prima facie evidence to demonstrate that if believed, the claim is sufficient to justify a verdict. And this is important, right? If you don't establish that, you don't win the case. If you don't establish that, the case is thrown away. And in a civil case, an example could be, take your tenant to court and you conclude that the tenant has destroyed your building, right? Because that destruction is right in the premises that the tenant is renting. That is your conclusion. It could be somebody else that is responsible for that destruction, and not the tenant. You're first thinking, and at face value, you conclude it's the tenant, and you take the tenant to court. So the plaintiff must establish a prima facie case to demonstrate that, if believed, the claim is sufficient. So what is the claim here? Destruction, right? This is property destruction. That is the claim here in the civil case. Now, you conclude because it was destroyed within the premises being rented, that somebody else could have done it. But if the renter cannot prove that somebody else, not them, did it, well, your case carries, because there's nothing to contradict your claim, contradict the prima facie evidence that you've presented. You presented pictures and videos of the destruction, and you presented the lease that has dates. For example, January 1st to December 31st of a certain year, and this person was renting during that time, as indicated in the lease. So you bring that evidence to court, and you don't have the other evidence that somebody else did it, but then the tenant brings a video to court that suggests somebody else destroying the property from outside, unknown person destroying the property. That video is sufficient to dismiss this case. Without that video, this case carries. Now you get the picture and you get where we're going with this. So in tort law, then, a prima facie tort claim requires the plaintiff to prove the defendant caused harm, shifting burden to the defendant to justify their action. The defendant caused harm. And harm here is not really physical, not physical harm, but reputational harm. You caused harm to my reputation as a company, as a business. You caused harm to my standing in professional standing and business standing by making false claims. You said this on so day, and that cost me business. I lost customers. And by losing customers, I lost money. If you can prove that, then you win the case. But if you can't prove this, if this is not sufficient, and the person, the defendant, has evidence to the contrary, well then, guess what? You don't win the case. So let's take a look at this again. A prima facie tort claim requires the plaintiff, person suing, prove the defendant caused harm, shifting the burden to the defendant to justify the claim, the action. So the defendant can't say, I did not cause harm. I only said that perhaps, allegedly, I did not say conclusively they did it. I said allegedly, and I talked about my experience. This is my experience with their product. This is how I tested the product. It didn't test well, and I threw it away. That is what happened, and that is my experience. Now, somebody else may have a different experience. I did not defame this company. I did not bring down their reputation. I simply stated my experience with their product. Well, if you put it that way, well, you have a case. You stated your experience. Your experience is your experience. Your experience is your fact. It's your gospel. It's what you have seen and experienced. You are not saying that this is what everyone has experienced. You are not saying that the company is a terrible one. The company is defrauding. You simply stated your experience. Just like driving on the road and you run into several potholes and you tell people that I ran into 5 potholes. Well, did you run into 5 potholes? Yes. Well, that is your experience. The city cannot sue you for defaming its reputation. And the Department of Works that takes care of roads cannot sue you for defaming its reputation and bringing its abilities and capacities into doubt because you simply stated your experience. You ran into 5 potholes, and that is what it was, and that's a fact. So this is very important. In the grand scheme of things, in the legal aspect, prima facie evidence is very important, sufficient to bring a case, and if it's not refuted, it's not reported, it can carry the day. It can win the case. It is important to note that prima facie evidence is not conclusive. Not conclusive. It only suggests a case is valid until proven otherwise. Please take note of this, students. If you take nothing out of this, this is what you should take from this lecture. Let's say it again. It is important to note that prima facie evidence is not conclusive. Not conclusive at all. Just enough to suggest. The example of somebody running away from a room with blood on their shirt, and you go into the room, you see somebody in a pool of blood, just sufficient to arouse suspicion. To say, wait a minute, what is going on here? What did you do? To begin to ask questions, etc. Not conclusive. In that scenario, there's nothing conclusive about it. You did not see anything. There could have been a third person, a fourth person, a fifth person. This person could have been running away from danger and being a victim himself or herself. All of those things are possibilities. But you conclude that no, they are the ones that did this. It's not conclusive. It's just suggestive. Not conclusive, but suggestive. So let's put that here. Not conclusive. This is conclusive, but suggestive. Please take note of this, students. Suggestive. That is prima facie evidence, and is part of the terms and concept in legal cases across the spectrum that have a bearing on cases and how cases are determined, how cases are seen, how cases are processed, how cases are evaluated, and how cases are adjudicated. prima facie evidence.